versus CA from EAC, Office of Deputy Commissioner SEPA.
PIO नहीं आया ना. ये सेकेंड हियरिंग है ना आपका. तो हम लोग ने फर्स्ट हियरिंग में आपका सामने PIO को आने बोला और एक ऑर्डर भी किया, उसको समन भेजा है आने के लिए. आज भी नहीं आया. उस समन में हम लोग ने ये बोला कि अगर वो नहीं आने से उसको सेक्शन 20+1+2 के तहत उसको जो जैसा एक्ट में लिखा गया है, हम लोग को पावर दिया गया है, उसका थ्रू हम लोग एक्शन ले लेंगे. तो उसका एक्शन है, पेनलाइज करता है. बीइंग responsible officer in a responsible chair, he should know that he has a statutory duty to attend to statutory court hearings of the commission. So the commission order should go. The commission had already issued a summon notice to the PIO on the first hearing, that was on 21st May 2024. Wherein it was categorically stated that the commission, the PIO provide the information to the appellant as he had sought in his Form A application. And to appear before this commission today without fail, for which someone show cause notice was issued to the PIO with the order that his failure to come to the court will attract the provisions under section 20+1 and +2 of RTI Act 2005. As it is evident that he has failed to turn up or failed to send a representative of him to attend to the hearing, the court deems it a gross misconduct on the part of a responsible officer chairing a responsible post, and it is to remind to the PIO that besides public services, being a public servant, he also has the duty to attend to courts whenever an appeal is made against him in the court wherein he is a party to the appeal, and his repeated absence shows his insincerity as well as insensible ethos and conducts towards the law of the country. Therefore, someone notice be issued to him to attend in person in the next date of hearing, which is on what's the date? On 22nd August 2024, failing which the court will decide the appeal ex parte in the absence of the PIO. The next date of hearing has been intimated to the appellant, and so no formal notice required to be issued. And the order be sent to the PIO so that it reaches to him before the next date of hearing. ये अभी सेकेंड हियरिंग है तो एक थर्ड एंड फाइनल एक उसको फेयर चांस एक देगा आपको भी वैसे ही एक चांस देना है कोई केस में ना एक बार में दो बार में डायरेक्टली एब्रप्टली ऐसे उसका खिलाफ में जजमेंट दे दिया वो भी नहीं बनता है कानून ये कहता है कानून का फर्स्ट प्राइम ड्यूटी है कि सबको एक फेयर चांस देना है तो अभी एक समन हम लोग भेजा है पहले एक नोटिस इशू किया आज समन जाएगा कल उसको तो उसमें थर्ड हियरिंग में नहीं आने से हम लोग जजमेंट को डिसाइड कर देंगे उसको वो आओ मत आओ एंड एन ऑर्डर ऑल्सो शुड गो to provide the informations to the appellant as sought on or before the next date of hearing. And to intimate the appellant properly, taking due diligence before providing the informations on or before the next date of hearing. हम लोग नेक्स्ट डेट ऑफ हियरिंग में डिसाइड करते हैं तो बताया ना 22nd ऑफ अगस्त
10:30
10:30 सुबह ना सुबह
151
ये भी सेम ही है ये भी वही सेम आदमी है जी हाँ ये भी सेकेंड हियरिंग ही है इसमें भी सेम पीआईओ ही है हाँ तो सेम ऑर्डर चला जाएगा उसको सेम पीआईओ ऑलमोस्ट सेम केस है तो नेचर ऑफ वर्क तो एक ही है प्लेसेस डिफरेंट डिफरेंट हो सकता है एक आप एफए फर्स्ट एफएट अथॉरिटी का ऑर्डर को आप अटैच नहीं किया था लास्ट टाइम में आपके पास है बोल रहा
हमको मिला ही नहीं है
ओके एनीवे हम लोग
मेरा सर जो लिखने बता दीजिए
ठीक है
यहाँ में हियरिंग नोटिस को
जी
दिया
जी
है ना हियरिंग नोटिस दिया हमने डीसी ऑफिस को सबमिशन किया था वही वो मैंने सीधे ये रिसीव है
जी
ये रिसीव है। तो हम सबमिशन किया था कि मतलब जो पूरा हम कई जगह में वो था ना, सर को हम बोला पीआईओ को डायरेक्शन दे दो बोल ना, डायरेक्शन दे दो, इंफॉर्मेशन पब्लिश करने दो बोल के लिखा था। तो लास्ट में वो लोग का ये हेयरिंग का 22 का हेयरिंग में 22 22 फरवरी का हेयरिंग का उसका ऑर्डर कॉपी हमको नहीं दी। अभी तक पहुंचा भी नहीं, वो से बिना पहुंचाए ना फाइनली कोई कोई कम्युनिकेशन नहीं है।
हम लोग वो आपसे सुना है, एक हियरिंग भी हुआ है, आपको आज तक ऑर्डर भी नहीं मिला तो उस ऑर्डर में तो जैसे भी हो आपको इंफॉर्मेशन प्रोवाइड करने के लिए फर्स्ट एपलेट अथॉरिटी तो लिखा ही होगा, लिखेगा ही वो। लेकिन आपका एड्रेस को सही से आप वहाँ दिया है तो ना,
यस सर,
तो आप भी एडमिट कर रहे हैं कोर्ट में कि फर्स्ट एपलेट अथॉरिटी का एक ऑर्डर निकला है, फर्स्ट हियरिंग में ही आपने एडमिट किया है, उसी का चलते हम लोग हियरिंग कर रहे हैं। नहीं तो हम लोग वी वुड हैव रिमांडेड बैक दिस अपील टू द फर्स्ट एपलेट अथॉरिटी। हम लोग हियरिंग दे रहे हैं मीन्स फर्स्ट एपलेट अथॉरिटी का ऑर्डर का बावजूद भी आपको इंफॉर्मेशन नहीं दे रहे पीआई, उसको हम लोग उसको वी हैव टेकन दैट इनटू अकाउंट, इसलिए वी आर going on with the hearing of your appeal. So on the same day, next date of hearing में same way the same orders will go to the PIO। अब डेट को वही सेम डेट को उसमें एक बार वो एक hearing करता है, सेकेंड चांस एक देखता है।
Number 105. Shri Vijay Taram versus CI from Executive Engineer Department of Power Dam Site.
कुछ कोई है नहीं है ना? So this is the third hearing. The PIO has always been present while the appellant is always absent, and the court has repeatedly issued notice to the appellant to be present in the court while hearing and to deposit the amount of rupees 60,630 to the office of the PIO. But till now, it seems that he has failed. And this is the third hearing. And in the last hearing order, this court has stated that on the absence of the appellant, we will hear the appeal ex parte. So it seems that the appellant is not interested, not willing to go ahead with the hearing of his appeal, and then he's not actually willing to pay the money as calculated by the PIO. So just with some dubious reasons, it seems that the appellant has filed the RTI in his Form A with some dubious reasons for which he is not willing to collect the information despite the repeated orders, reminders to PIO to submit an amount of rupees 60,630 and to collect information. So this court is of the opinion that the unwillingness of appellant is clearly shown by his repeated absence in the hearings for the consecutive 3 times, and therefore taking serious note of the appellant in unnecessarily disturbing and wasting the resources of the PIO, who is a public servant and who, by incurring public money, has readied the documents to provide to him. But in many attempts from the office of the PIO, the appellant has not paid the money or not bothered about the information. And therefore, the court, with clear mind, feels that such type of appellants should be made to realize that their insincerity in applying for the information makes other appellants also to be non-serious in their applications. As the very Act, the RTI Act 2005, does not provide for any penalties upon the appellants or applicants, those who are non-serious but apply for informations, and while the informations are ready in the office of the PIO, they don't turn up to collect the informations, nor they turn up in the court hearings of the appeal, which seems to be bit handicapped on the side of the RTI Act itself. Whereas on one hand, the Act precisely says that applicants should not be allowed to waste the resources of the government, the departments, but fails to put certain strict conditions to such non-serious applicants or appellants who in fact make a joke out of this act to the office of the PIO, to the office of the first appellate authority, and to the second appellate authority, which is the respective state information commission. By seeing the turn of events in this very appeal, and by seeing the sincerity of the PIO, who has never failed to attend to the hearing, and by seeing the insincerity of the appellant, who has never turned up for any of the hearing in the consecutive 3 hearings, the Commission disposes of this appeal instantly, with no liberty given to the appellant to ask for fresh information on the same subject. Hence, the appeal is disposed of. So we have disposed of the case, we have seen his insincerity, and also we have acknowledged your sincerity in the orders itself. And we have also made it a point that the act should have been strict on such insincere people who simply disturb the functioning of the public servants, public offices, as well as the time of this commission and the resources of the government that has been invested to ready the documents for it. So we have disposed of the case, and we have also categorically stated in the order that he cannot file a fresh application again seeking for the same information. That is very clear. Because you are ready with all the information. Yes. He is reluctant to take the information again. So this is very serious. We have viewed it very seriously. Maybe tomorrow or day after, on any day, he will come to us and we will let him know of the order of this court. So the case is disposed. Thank you. सर one thing I want to ask, sir, one clarification I want. Yes. सर उस दिन एक आरटीआई आए थे जी, तो 30 डेज में हमको इंफॉर्मेशन फाइल करना है, देना है जी। तो क्या हुआ जब हमारा पेपर कैलकुलेशन और ये में आई टुक 7 डेज टाइम, मैंने उसको लेटर लिख दिया कि मेरा डॉक्यूमेंट रेडी हो गया, तो 7 डेज एंड ये जो है हमारा 23 डेज रह जाता है जी। तो मैंने उसको लिखा था कि विद इन 23 डेज आप आके कलेक्ट कर दीजिए। तो उसने आरटीएस सीकर ने हमको आगे गुस्सा किया, हु यू आर टू डायरेक्ट मी टू कलेक्ट विद इन दिस पीरियड, ऐसे हमको बोला। मैंने इसलिए उसको जस्ट ये जवाब दिया कि हमको इंफॉर्मेशन पास करना था आपको विद इन ए मंथ। So 7 days already I have already consumed. So remaining 23 days is left with me. That's why I told you to collect within these 23 days. तो उसने बहुत गुस्सा होकर हमसे झगड़ा उगड़ा करके चला गया। तभी भी मैंने जब उसको बोला कि दिस इज लीगल मेथड में हम उतना मालूम नहीं है, लेकिन हमने जो समझा मैंने आपको लिखा। So इसमें मेरा पार्ट में कुछ गलती था क्या सर? नहीं नहीं, you have the full authority, you are the competent authority whenever an application is submitted to you. The day starts from the date on which you receive the application, not from the day that the applicant has posted it or submitted it in your office. But the moment you receive it, then only the counting day one will start. And The very day the informations are ready, you also have a obligation to inform to the applicant that the informations are ready. And he cannot be protesting before you like that, that who are you to tell me? It is the question. Yeah. And also, I don't have our knowledge also. Our people, what we have seen in this, what I have seen in this court is some of the applicants are still in not in the best of positions to know the provisions of the act itself. So you have done a very good job actually by providing, by reading the informations within 7 days. That was really better for him. So the day the informations are ready, you have to inform the applicant. That is your obligation. And within 30 days is the time limit. And beyond 30 days, if certain reasonings are there for condoning the dates beyond 30 days, if they are really sufficient and very genuine reasons, it can be condoned. There is, we are not wrong in any way by giving the information within a day or within 30 days. So that also I have sent through WhatsApp also. Yes,
By
WhatsApp.
getting that WhatsApp, he came to my office. We were to directly to
Yeah.
collect that also within this day.
WhatsApp receipt, there are two tick marks. Tick mark means the other person has received it.
Yeah.
And then blue mark shows that the other person has read it.
Yes. Sir.
So the Supreme Court also has now acknowledged that once you send me something, two tick marks appear on your side of the mobile telephone, it is presumed that I have received it. Even if I read it or no, that's my obligation or liability, my liability. But on your part, you have sent it, that's more than enough. You have done it actually genuinely within the rights.
Thank you, sir.
Yeah.
Ethic number 104, Riya Taram versus PIO Executive Engineer, Department of Power Unit.
So Riya Taram is absent. He had another case also. Yes, hello. Good afternoon. Let me see the format.
Second. Yes, again.
Yeah. So, PIO, what do you have to say on your statement that you have? Yeah. Can you tell us about your reply to the so-called notice that you have replied to us in brief? Yes. यस। तो अभी एपीलेंट नहीं आया है आपका। जो फर्स्ट हियरिंग, सेकेंड, ये थर्ड हियरिंग है। जी जी। सेकेंड हियरिंग में भी एपीलेंट भी नहीं आया है, फर्स्ट हियरिंग में भी एपीलेंट नहीं आया है, ये थर्ड हियरिंग है। तो थर्ड हियरिंग में we presume that when the interest party does not attain the hearing for 3 consecutive times, any court of law presumes that the party is no more interested with his case. So in this instant case also, the commission presumes that the appellant is no more interested with his appeal. And so without going into the details of the case, by going through the simple understanding of the fact that the appellant is not at all interested with his appeal, I feel we don't need to hear this appeal anymore. So we will dispose of the appeal today, because the order from this court, from this commission, have been sent to the appellant thrice with the strong wordings that if he fails to attend or you fail to attend, any of you, we will decide the appeal ex parte, and today you have clearly and satisfactorily intimated and convinced to me that your absence for the first time was due to election duties. That is well accepted, well understood. And then the failure of you for the second time was due to your medical reasons. That also I accept. I accept that. But with all humility, I only suggest one thing. In case of your incapability of attending to any court hearings wherein you are a party, make it a point to remember always that send a representative of yours with an authority letter signed and sealed by you, and at least he can go to the court or to any other body where at least you will be represented if you are unable to come personally also. That is just a suggestion to you. But yeah, here in this case, the sincerity of the appellant in pursuing this appeal itself is proof that he is not at all sincere in his appeal. And therefore, be without taking other regions into account, only by taking the insincerity of the appellant to move this court and then abstain from hearings even after repeated orders and intimations and reminders from this court, he has failed for the third time. And for this very reason, we presume that the informations that he has sought are actually not wanted by him anymore, and therefore we dispose of the case today with the liberty to the appellant that as the informations have not been provided by your office to him also, he will be given the liberty to file a fresh RTI applications if he needs to. But in this very instant appeal is disposed of today. That's it. And the next is